Good afternoon, everyone here present in beautiful Karlstad and also online. As Vitor explained, and as you can tell from the fact that I'm the only one in the room except one gentleman with a very nice tie, I'm the only one wearing a tie, so you can trust that I'm a lawyer. And I wanted to pick up and present this panel before introducing my distinguished panelists by quoting my boss, who said we like to speak about challenges and not problem. Well, this panel will have to deal with the law, with what is human oversight, what is being made of human oversight in the two most important pieces that we have right now in union law, which are the GDPR and the freshly baked AI Act. And to do so, I think we probably need to use the word problem, not just because I'm a lawyer with a tie, but because after this very nice introduction by Ben Green, I think we clearly have a problem definition. We have a very clear structure of what is the problem that we have to deal with. And a challenge is there when we know what the problem is and what is the solution that we want to achieve. So I think today's discussion will hopefully help us to transform the problem into a challenge and to start looking for the right track to find solutions. I think we're not going to find them today. I don't know, maybe. But certainly I have two panelists that are very much qualified, much more than I am, so I should quit talking as fast as I can. But not before introducing, to my right, Claes Granmar, and I trained in pronunciation on Swedish first names, but I think I still failed. Anyway, Claes is researcher and associate professor at the University of Stockholm. He has a very varied academic background, but with a common thread, which is European Union law, with a focus on fundamental rights and how fundamental rights work across the whole field of union law, if I may say so. He's particularly focusing right now on digital globalization and the EU digital internal market. Welcome and thanks for coming. Then we have connected online, good afternoon, Ben Wagner. Ben Wagner is Associate Professor of Human Rights and Technology at the Technology University of Delft in the Netherlands. And he's also a Professor of Media, Technology and Society at In Holland University of Applied Sciences. His research focuses on the governance of complex social legal systems, in particular human rights in digital technology. Thank you again for joining us. So, few housekeeping rules. There will be two presentations by our distinguished speakers. Then I will try not to look too much like a fool with some questions from my side. But most importantly, I'm expecting your participation with the final session of Q&A, also, of course, extended to those who are following us online. So, Claes, the floor is yours. You have 15 minutes.
Well, thank you very much. I will try to keep the time. It's, of course, a lot of ground to cover. And thank you very much for inviting me to share some thoughts on human oversight and AI systems. And if I understand correctly, most of you are into computer engineering and science, and perhaps your modus operandi is to solve problems to make better, faster, more accurate, and more secure machines. But of course, as Wojciech said, this human drive, so to speak, and ingenuity and ambition is essential for also social development, but also is a route to the abyss of horror and destruction. So the legislator and regulator has mainly two normative tools to implement decisions and hopefully promote a sustainable social development. It's budget and regulation. And of course, when it comes to budget, the public powers invest in private firms and also public budgets like this university to focus on certain areas to develop AI systems. And I will today focus on the regulatory side of this governance, so to speak, and particularly on human oversight and the AI Act. Because just to clarify from the start, we have been mentioning the GDPR, and the GDPR is specifying the regulation of one particular human right, namely data protection and privacy. So this is a very comprehensive legal framework, but it's just one right. And the AI Act covers all rights, all human rights, environmental protection, to procedural rights, to data protection. And of course, many machines will not take individual decisions, so we have to keep this in mind, that we're talking about human oversight of AI system, not only with respect to data protection, but in a very, very broad range of activities. And we have heard there's a lot of problems, but I think also there's another approach. We have the empirical approach here. I'm a lawyer, I'm an e-lawyer, I talk about structures and systems. So, I mean, on this level, we can't go into the detail what someone has to do in certain particular areas. We can only talk about the system, and that's what I'm going to do. And to start with, then, the legal mindset, it's very different from the mindset of perhaps the developer of an AI system, because the mindset is to constrain human curiosity, constrain ingenuity and ambition, and to channel these resources towards certain identified objectives. So the fact that you can do something is not a good reason to do it. That's a legal mindset. I think that's very different from the developer on AI system. To find a solution, that is a good thing. Per definition, it's not a good thing for the lawyer. It's a problem. We have to solve it, as also Danielle pointed out. So what can the controlling natural language do? Well, it has to respond to changes in the human conditions, technological, sociological, political, whatever you have. At the same time, law can create realities. And that is a very important point. I mean, law is one contributing factor to the design of this room, for instance. You have certain measurement and all that. It's legally required. It's a very important reason to why your toothpaste has a certain formula, and it's the main or only reason why we are driving on the right side of the road here in Sweden. So law creates realities, and often we're not even aware of it, because these legal standards, they become human behavior, habits, and the way we just do it. And when it comes to product standards, of course, that's a more technical side of standardization, but it also, we take things for granted that products have certain features. It's often the product of standards, and based on scientific research, know-how, and best practices. So information technologies has already a lot of standards, as you know. Technological standards with legal sanctions, so law has already created systems. And this is good for, I mean, the human individual and the society, but also for the industry. And this is often forgotten, because interoperability is a key factor of efficient resource allocation. If you don't have it, then you have, I mean, entry barriers and deadweight losses from a market regulation point of view. And also in the European Union, to have the same standard across the member states creates a huge market. You have one standard for a huge market instead of having to learn about 27 different standards, regulatory frameworks, with stifle trade and competition. So, and this applies also, this is a starting point why the AI Act is good. I mean, from my point of view, it's a very good thing. It's not a problem, it's not a regulatory burden, it's a good thing, because it creates a possibility for companies to develop, allocate the resources in an efficient way, develop good AI systems that fit the bill. Of course, AI has a particular normative challenge, so to speak. It's 3 different aspects that need to be taken into consideration. The ability of the system to infer from internal and external input and to change its output. And even if the machine code is okay from a regulatory point of view to start with, it can infer and derail eventually. So, and this lack of human capacity to understand the code creates a black box problem. Secondly, this is an unprecedented social changing potential in these systems. And people are inclined, nevertheless, to hand over decision-making powers, so people become more dependent on them. At the same time, the lack of moral agency and susceptibility of human sanctions create this dissonance between decision-making power and a possibility for humans to punish the wrongdoer, so to speak. And this is also a possibility for humans and natural legal persons to hand over liability or blame the AI system, saying that, well, the system did this, the system did that. We didn't know, we couldn't do anything about it. That undermines the whole legal system because someone has to be held liable. So even if it's an imperfect system, someone must be liable. So from the structural point of view, you can have an empiric evidence saying that the humans doesn't help. Well, it doesn't matter. Someone must be held accountable for this problem from a legal point of view. And since we can't address the machines, so to speak, the AI Act addresses the providers and deployers. In a way, however costly it might be, the main objective of the legislator is to prevent the singularity, as we all know about, that there's no room for the human in the equation. That is the main overriding objective, whatever it costs, because in the long run, the cost might be much bigger not to stop this development for the humans. And also, there's no good reason from a human-centric point of view why AI systems or things that are governed by AI systems should not be subject to the protection of human health and human security and fundamental rights. There is no good legal reason that we have other rules, with respect to these machines than to anyone else. No, the same legal standard applies to everyone, including those who deploy AI systems. And therefore, we have, Recycler 73 specified this very clearly that the provider of the system must build in mechanisms to signal to humans that something is wrong and make it possible for a human to take a decision. And on the other hand side, the human must be educated to be able to understand the signals and do something intelligible out of this information. This is how the system is built. Then in practice, in this situation, that situation, I don't know, no one knows how it's going to be operationalized, but someone has operationalized it in this way. So the AI Act does not shift any burdens or responsibilities here from the providers to the deployers, because the provider has of course a responsibility for the machine as it's built, how it is built, and also even if it's verified from the start, it complies with all the regulations, it's okay, you can put it on the market, fine, but then it does not signal the right thing in the right time to this human being, then it's still the liability of the producer. So, but on the other hand side, the continuous oversight must of course be carried out by the deployer. So it might come as a surprise for some people that the black box problem might not be a legal problem; it might be a technological problem. The legislator might say that we don't accept this in the European Union. You need to focus your resources to develop transparency. And this is what I started by saying, that law creates a reality. The reality is not given that whatever we can do technologically is okay. No, the reality now is that everyone who wants to sell their AI systems in the European Union, high-risk AI systems, they need to ensure transparency. And if they can't, so be it. Then you can't sell it in Europe. And of course, there's an argument here. I will try to, then make this very dense, condense it very much. But there's a disadvantage for European producers of AI systems because the Chinese and the US producers don't have these legal obligations. Well, they have, because if they want to put their machines on the European market, on the internal market, they need to abide by the same standard. So it might be in the short term a loss, but on the other side, the European Union is the biggest trading bloc in the world, and the European companies, they will have their sandboxes, they will learn much quicker about this, have better access to authorities and all, whatever you like. So they will probably learn these requirements faster in each sector, and so they will have an advantage in the long run. And this is a small piece in a big EU strategy to use the powers of this trading bloc to export the human rights standards and create a value-based international human trade regime. So this is a strategy that the European Union has. It's not a coincidence. Well, I don't know if I have time to go into the interlinking here between, but I can briefly say that both when it comes to impact assessment under the AI Act and under the GDPR, it's carried out by public authorities, of course. But in some cases, you have an obligation. You have always an obligation if it comes to an AI system that takes decision and process personal data. It's a high risk for the data subject. Then you always have a liability to carry out an impact assessment. But you don't have this liability in all applications or deployment of AI systems, so there might be a mismatch. But for instance, when it comes to cars, yes, you have to have an impact assessment under both the AI Act and under the GDPR if the car is taking individualized decisions. So in this instance, the AI Act says that we accept the assessment under the GDPR. But from an EU law point of view, the main problem here is to create an institutional framework that can coordinate these things to make it a little bit easier for the companies to have one assessment. But it still is so much is clear. If you have made an impact assessment under the GDPR, it will be accepted under the AI Act. Down the road, we have a directive. The GDPR is basically based on private enforcement. We have this ex ante in advance impact assessment when it comes to high-risk systems and decision-making systems. Yes. This is the GDPR, decision-making systems. And we have a more ex-ante approach under the AI Act, which means that the whole AI Act is a product safety regulation, basically. You know, you shall comply with things, you shall be certified, and then you have a continuous control and contact with authorities ex-ante before something happens. The GDPR is something happened, some processed your data, you can bring it to the EMU and so on and so forth, ex post facto. But there's a directive now on the way from the EU with respect to AI in general, which is also ex post facto civil liability for anyone, any person who feels ill-treated by those who deploy the AI system, they can bring an action. And then there is an assumption that if it's a high-risk AI system, well, then you don't need to prove anything. It is probably your fault because you have all this requirement under the AI Act. If it's a low-risk system, then you have to prove it that you did something wrong to make the machine take this decision. Well, you can see that I'm speeding as fast as I can, and I think this is what I can say for now. And thank you very much for your time and for your attention. Thank you.
Thanks a lot, Claes. I think it has been quite enlightening. And even if you're not wearing a tie, I really liked when you said that even if we all know there is a black box problem, and the human in the loop probably cannot be the magic wand, the silver bullet that will solve that. Still, legally, we have to find someone who will pay the damages at the end of the day, and that someone can be either the poor overseer, maybe that is there to lighten the burden of his company, or his company, rather, his organization, the legal person that we lawyers will like to almost equate to natural persons in certain situations. Ben, I would give you immediately the floor to continue this interesting discussion from your perspective. The floor is yours.
Thank you so much. Thank you for the kind introduction. It was great to hear both previous speaker and also Ben Green as well. Very interesting to have this overview, and I think it really helps us to understand. To summarize briefly what we've heard so far, I would argue that what we've heard is to this point that first we are facing a problem of governance. Next, we are facing to a certain degree a technological problem. And what I'm going to argue now is that actually the existing legal frameworks are what is creating the problem rather than any failure of governance or technology. So if we look at the existing legal frameworks, there's a strong impetus, both in the GDPR and the AI Act, to claim in different, maybe slightly silly, but in different ways, that your mechanisms are not actually automated. So if you have an automated system, there's all sorts of responsibilities you have, there's all sorts of things you need to do, there's all sorts of things you need to consider. And these types of regulatory requirements are not similarly the case if you have a non-automated system. So there is a strong impetus under the GDPR, under the AI Act, under other regulatory systems to claim, whether it's again true or not, we've already heard about this from the previous speaker, that you don't have an automated system. Now, from this, let's say, legal context, I think flows a lot of the decisions that the online companies and also digital companies are currently making right now to both make claims about their systems and then to provide certain forms or certain mechanisms of responses to those claims. So we see what we've heard already, systems being implemented with a sort of very mediocre human in the loop. We see human oversight implemented in ways that is sort of quite superficial and limited. And we see human beings essentially put somewhere in the process to avoid legal liability, rather than actually attempting to ensure that they have effective agency in the decision making. Now, I'm not saying that we should then necessarily reduce or limit the protections that exist both for consumers and for citizens in those contexts, but rather I'm suggesting that the way the legal regime is designed right now, there's an incentive for different actors in that regime to make claims about their systems. And so as the previous speaker always mentioned, it would be quite easy now to say, well, if your system doesn't fit up to European requirements, if your system is not transparent, then you can't sell it in Europe. And there I think it's a coupled legal problem with a relatively limited degree of enforcement, coupled with a limited, let's say, willingness to go against the existing potential hopes and dreams of what AI might be. And this then leads to a certain form of regulation, which is you can do these things as long as you make sure that somehow the systems are at least a little bit protected. So we have some humans in the loop to make ourselves feel better about the fact, even if we know that actually they won't create the change that we're hoping for. So in that context and in those situations where we are having these sorts of things, I believe that there are some quite concrete things that could be regulated and changed differently in order to shift the way that that works. And the first is the presumption that a system is automated or manual should not change the way that it's regulated. The protections that are received by individuals in that process should be the same. And given the complexity of the way, let's say, human-computer interfaces, the way technological systems interface and don't interface with the people who are supposed to be the human beings in the loop, I would argue that the presumption of automation should be consistently present throughout all of the legal reasoning. Now, that would first of all take away any incentives that any of the actors involved had to actually pretend to be non-automated. So you would take away the need to have a click worker sitting there and clicking yes, 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 yes. And then the provider in a very superficial way would be able to at least claim in a very superficial imagination to say, actually, this is not an automated system. And we would be in a situation where we would have a far greater degree of protection for what we call these quasi-automated systems, things that seem to be manual but are actually automated. And we've found surprisingly common in many different areas in our research. So it's not to say that there are things that need to be radically changed, but rather that the presumption of automation itself should be at the center of any future way that we think about human decision-making. Because then once we assume that things are automated and assume a higher degree of protections, the incentive structure changes, and then we're in a very different set of conditions within which it's possible to try and move forward the way in which we talk about these systems, rather than getting stuck in this constant conversation. Is it automated? Is it not? Is it sufficient risk reduction if we put a human in the loop? It's automated. And it's automated to a sufficient degree that if the automation is present there, then we can also start to move forward in a slightly different form of system design, rather than getting stuck in trying to pretend things aren't automated that clearly are. That's all from me. Thanks very much for listening.
Thanks, Ben. This is very thought-provoking. I think while I was listening to you, we can perhaps present a binary choice. There is our legal reality, which essentially is proposing a smokescreen, scapegoat. So as soon there is a human in the loop, the law creates a fiction that pretends all is fine, tout va bien, Madame la Marquise. But the reality is what you called quasi-automation. If I would continue on this rather extreme and find the opposite extreme, then, well, let's get rid of this poor employee that also in Ben Green's presentation has been highlighted as a scapegoat, so somebody to blame, but that has no real agency. I think in Ben Green's presentation, we also explored some limits of explainability. So even when the poor employee, scapegoat, overseer is confronted with a clear explanation, such a clear explanation capable of overcoming at least part of the black box problem, so he would really understand something, this guy, but still there would be reliance on the output produced by the machine, by the artificial intelligence. So it's true that as a lawyer, I like problems, but I think we need to make a step further. Perhaps we are probably at the level of a debate in which I would invite both of you to see, okay, what do we do first with the law that we have, and how to make it work with the instruments, with the legal instruments that we have. And now we know we have the GDPR, and Claes explained what's the difference in approach between the GDPR and the AI Act. I think, however, that it will be essential for all of us in this room and outside that the two instruments work at their best together for all the flows and the conceptual problems that probably those two instruments, even applied by the best data protection authorities or by the best judges in the world, will not be able to solve completely. But still, artificial intelligence is there. The GDPR also is there, and it's shyly starting to be enforced. What do we make of it? Well, how do we make it? Is there an alternative, Claes? Do you see an alternative or a piece for solution to this binary scenario that, perhaps exaggerating, I have created? So to sum up, on the one hand, quasi-automation, as Ben called it, is in reality automation. On the other hand, we want to start with the assumptions that humans must be in the loop somehow, but they should then be empowered with sufficient agency. And if they are, well, it's still probably the best assumption, the best constitutional and political and foundational assumption that also the legislator of both acts, the GDPR and the AI Act, made. I hope this question makes some sense to you. But I think, yeah, we can place a solution between those two extremes. Good luck.
It's clear as soup, as we say in another kind of, in Swedish, we have another expression, but it's clear as soup. Yeah, but it's of course very different on this level of abstraction to say something really clarifying, because there will be so many different scenarios. But I think in some fields you will be able to come up with very clear, people that are very knowledgeable, that can take very good decisions. In other situations, you will have someone working in a garage, just as a cover for in this system. What could I say? Proportionality is the answer from the EU law point of view. It's also about proportionality. There's no perfect solution, but good enough. It's fair enough. We have a sufficient understanding what's going on. We have sufficient possibility to solve it, and so on and so forth. But I want to stress again that you can paint different pictures, and you can come up. You have a technological reality in the laboratory, in the sandbox, where you come up with new solutions which are brilliant and very important, and some of them might actually be commercialized down the road. On the other side, you have an equally important reality, that is the legal reality. And that and both camps, so to speak, tend to forget about each other, because from the technological side, I'm always puzzled by this assumption that then we can do it because we can, and then we must solve it legally. Well, I mean, the thing is that we have legal standards. Either you also without the GDPR, also without the AI Act, you would have the same legal requirement, because we have the EU Charter of Fundamental Rights, which applies to everyone. Someone has to be held liable. It can't be the machine. We don't want it to be the machine, because that would be a way for these other people to get away with anything, just playing the machine. What can we do about it? Shut it down. Okay, who cares? So in order to have the legal system functioning, someone must be held liable, a human being, a company, and they must abide by European standards. The thing is that other big players in the international field, they don't have so strong human rights standards, but we have them in Europe. That's a fact. That is a fact. That is something that the technological side must realize also, that it's something we can take lightly upon. We must build a machine in a way that they secure the fundamental rights. Otherwise, you're making something illegal. How you're going to do it, and where the people comes in one scenario or the other, one sector of trade or the other, that is so complex. I don't know. I mean, of course, also people need to have certain educations, and you will probably have certification of people who can take care of these things. But it will look very different in different sectors. That's the only thing I can say. I understand the problems. I don't have one answer except for proportionality. Good enough. That suffices.
Well, I always like proportionality as an answer, by the way. Ben, may I ask you to try and answer yourself to the question implicit in your intervention? And I was thinking, may I go a step further and tell you, I work for the European Data Protection Supervisor, and as the supervisor himself stated, introducing today's works, we have the task of advising the legislator. What should we advise the legislator the next time, when maybe in a few years' time, this is a bit science fiction, but it may come one day where we will be asked, how do we get out of this conundrum? How can we ensure that this automated decision is in line with the rule of law, so we have a liable entity, but at the same time this entity has real agency, so we can impute those actions to a natural person or a legal person. Is there at least a piste de réflexion? I see you nodding. That's always very encouraging for the moderator. Over to you. And then we also have a question from the audience that we will take, and maybe Claes, you can, I would probably shift it to you again. Go ahead, Ben.
So I think there's a few things that can be done, and I don't think any of them are particularly complex. I don't think they even necessarily require new legislation, but they require a different interpretation of existing legislation. So I'm sure you're familiar, there's beautiful and existing decisions that exist from the Article 29 Working Party. And I very much enjoy when I'm sort of looking at the guidelines on automated individual decision-making from, it says 2016, but they were adopted in 2017, that really sort of provide an attempt to sort of deal with these sorts of things. I think these sorts of interpretations and reinterpretations of existing things around the GDPR could in many ways be sufficient to think about how we do things. The core shift, and this would also be the core shift for legislation, would be to first presume automation, and then presume automation unless it can be proven otherwise that it's definitively not automated. And even if that is the case, you would still want to get out of the situation right now where there's an incentive, a legal incentive to suggest that things were non-automated, because as we've heard already from Ben Green, bad models can be implemented as long as we put in human oversight. If bad models were always considered to be bad models, regardless whether they're human oversight or not and regulated in the same way, then the incentive to create a sort of a fictitious human oversight system goes away. So there would essentially need to be no legal benefit from having an automated versus a non-automated system. Both of them should be treated the same. And this then also, the AI Act is a bit more developed on this. It takes a more of a risk-based approach. But there too, there's lots of weaknesses in how to get around that. So it's again trying to avoid creating the wrong incentives for companies to basically say, we will do all of the bad things we want, but we'll write down all of the risks and make sure that we take the risks very seriously. If that is the process, then you get yourself in situations quite quickly where what already the previous speaker mentioned, essentially anything goes. And this happens in the European market quite a lot, where just things happen and then we're chasing for years, for decades to regulate after, and all of the messy things that happened that have already stopped happening years ago. And so I think there's a second sort of process that you can see quite nicely in sort of, I would call it the sister regulation to the GDPR, which I don't think is so much the AI Act as the Digital Services Act, which is to have a centralized mechanism for large organizations that are in the market that goes beyond what is possible in the GDPR right now. And so if I speak to my students about the sort of the next steps in the GDPR, I often mention the DSA as an example of what might be possible without necessarily saying it has to be like this, but it's an attempt to learn from the challenges that existed with the GDPR and sort of move the regulatory dial further. So I would hope that some of those learnings can be integrated in future versions of the GDPR. But as I said, I don't think it needs necessarily a large regulatory change or a regulatory shift. I think the principles are sound. It's more about how do you ensure the right incentives and how do you ensure more effective implementation. With that, I think the principles can largely stay the same, but it's just sort of adjusting the way that things are organized and structured to ensure that a slightly different implementation is possible and a slightly different presumptions that creates then different incentives.
Thanks, Ben. I would leave then the space, the time we have left for some questions. We have one from the live audience. We have at least two, but I don't know whether they were asked in the proper way. But I will leave this to you, Xavier, to coordinate. In the meantime, we can take the question here from that.
Present yourself.
Good afternoon. Aranio Mary is for UK. My question, I'm going to give you a real life example as the only Black person in the room. I don't know how many Black people are online. So this is a British passport. I renewed it in 2017 at the passport office in London. It was same day service. I had carried photos with me. As you can see, I wear glasses. I was told when I got there that my photos were not satisfactory. I was told to use the photo booth. I was told to remove my glasses. I did all that and I walked away with my passport that same day. Now, at the time I was looking after my mother in Kenya. She had Alzheimer's. So 2018, I was coming to the UK for breaks. So March 2018, I arrive at Heathrow. I go to use the e-gate. Access denied. So I had to use a man desk. Then a few weeks later, I flew to Barajas Airport, Madrid. No problems getting into Spain with this same passport. Coming back to the UK, coming in via Gatwick, access denied. So in September 2018, I was at the Council of Europe for a conference. So fly to Frankfurt, no problem getting in. Then returning to Stansted, access denied. So I've worked in IT since 1990, been in information security since 2000, data protection since 2015. I've got a master's in information security from Royal Holloway. I've been CISP certified since 2002. Let me just stop with the certs. So I knew, okay, I was trying to figure out what is the issue? Because when I looked at the line of people who were at the man desk, they either had glasses or they were dark skinned. So that got me thinking. Then in 2019, there was an article on the BBC website which basically said that the Home Office had deployed this technology knowing full well it wouldn't work on people who looked like me. So their diverse training set, well, it wasn't diverse enough. So this is, so you guys, you're talking about your semantics about, you know, automation, not automation. I'm giving you a real life example. So I was, as Dr. Joy Bulamwini says, I was excoded by the state. So who do I go to for redress? And when you're talking about privacy, security harms, I mean, Daniel Solov has, you know, got the various categories. As somebody who travels while Black in Europe, we know that our personal experience, even if you've got legitimate documents, you'll be flagged up. Why? You don't know. So, you know, so I'm giving you a real life example. You tell me, you know, what redress can I get for something like that? Do I go to the Council of Europe? Who do I complain to?
Sure. Try to address that, Daniela, yourself.
Thank you for the question. So my assumption would be that you should go to the Information Commissioner because your rejection at the gates, he's determined very likely by processing of all your biometrics, which are your personal data. I guess you have thought about that. I don't know whether the Information Commissioner had been involved or followed suit, but what I wanted to say is something which is very important of what you said. And I think even today, the discussion was based on an assumption, which I would like to call the Skynet assumption from the movie Terminator. So that when we speak about AI, we're immediately projecting ourselves in the future. And it is true that it's also the present, honestly, because I think things are evolving very fast. But in most cases, I am tempted to think that in your case, the human in the loop worked. So when you went to the manual desk, probably because it was a system in his infancy, very much tainted by racial bias, a human recognizing you with the passport. I understand it's also a field where it's difficult really for the machines. And even the AI Act recognizes that because it requires a double human intervener for biometric identification, with some exceptions, but okay, let's leave them aside. The principle is that there must be a double human intervention. And perhaps this shows that, yes, there is a present and a future of artificial intelligence, and the presence is already doing a lot of harm. And I'm wondering whether the assumption of the human in the loop isn't really the lesser evil, is not the best, but is what we can do, what society can and the legislator can propose as a solution right now, even though it entails the quasi-automation, and we have listened to Ben Wagner explaining that. That would be my reaction. I would see this as a call for reality, and perhaps there also lawyers want to, because lawyers are called to enforce these rules faster than what people think, and these problems are already there. And there, you know, we have to find concrete solutions to this so that you are not again rejected at the gate. And I'm wondering, is there an alternative to a human in the loop in such a simple and perhaps hopefully starting to be a matter of the past cases, not just for the racial bias, but also for the refinement of the system, which I understand should be even from the automated perspective, from the point of view of the machine, should be improving in the future. I think, I hope. but if there are other reactions in the room, by all means, please, reaction or question. And then we take also, I think, 2 or 3 questions from the web.
Please.
Yeah, thank you. Thank you for bringing up this point. I think it actually shows that the human in the loop doesn't solve the problem, but actually exacerbates the problem, because you are flagged by the automated system. No matter that later by the human police officer, whoever behind the desk who says, okay, you're passed through, you are flagged, and you're always flagged. And it's only a small group of people that are being flagged for race, for whatever minority condition that is inherent in the algorithmic decision making. So I think this really raises a big flag in terms of like relying on the human intervention, because the first decision is made by the automated system, and especially if you as the receiving end of the decision become aware of that decision, and then later have to be pardoned by the human decision maker to overrule that decision, that doesn't change the fact that you are being the one always being flagged. So I think we have to be careful here, and thank you for bringing up that point.
Thank you. I'm not sure if the speakers want to react. Yes, Claes, please.
Yes, of course. This is a very good example. I mean, I'm sure you have legal remedies already now, and that is one of the point I'm trying to convey here, that, the AI Act and the GDPR never changed very much since we got the EU Charter in place, and you have all this legislation already in place in the UK. But the thing is that this is exactly what the AI Act is supposed to solve, to prevent these things from happening, because you will not be allowed to use these machines if they have these biases. That is one of the main points. So law, of course, creates this reality that it's not free to try an AI system as you like. No, that would have been illegal. Unfortunately, UK left the European Union some years ago. And also we have problems when it comes to the ECHR system with the fundamental rights in general in the UK now, because they are more free. I don't know. That's a big political question. It's great that you bring this up, and it's a great example of why you need the AI Act to clarify for everyone that, this is not okay.
Yes, we have many questions, but I will select a couple of them. The first question is, what are the implications for human rights if the main safeguard from the effects of automated decision-making, which appears to be human oversight, is known to be ineffective and superficial? Do we further limit the use of automated decision-making? That's the first one.
So I think Ben had a point here. It's about incentivizing. I mean, the AI Act incentivizes business to create better models, AI models, because this has to be solved on the technological side. So it's not a human being that can jump in all the time and solve human rights issues. The system must know when it can't solve it and hand it over to a human process. And so the answer is that it's not futile, it's not impossible, but we must learn about the limits of technology and the limits of humans. But at the end of the day, if the technology can't solve it, the human has to take the blame, and that is the best thing we can do. There's no perfect system, but the worst scenario would be if we don't regulate AI. That would be the Skynet scenario. Now we regulate it to stop this scenario to happen.
Shall I add? The human has to take the blame, or the state that has implemented an automated system which is clearly tainted by the racial bias, still having that one of the first bias detected in the earlier system and much simpler system. So that's a reason for concern. But yeah. Maybe if you can repeat the question, because it was a bit long, and then Ben or Claes, maybe Ben, yeah, your turn.
Mm-hmm. Yeah, The question is if we should further limit the use of automated decision making, because what apparently is the main safeguard against the issues coming from the artificial intelligence, okay, which is human oversight, is known to be ineffective and superficial.
Ben, we are looking at you.
I didn't see the look, but yes, sure, that's an easy one to answer.
Let me look at the camera.
I don't think it requires limiting the use of automated decision making. I think it rather requires taking it seriously. A little bit also, as some of my colleagues on the panel have mentioned, right now, a lot of the transparency and accountability mechanisms for automated decision making are, I'm trying to find a polite way to put this, but I'm lacking the words, are very, very, very bad. There's very limited transparency. The accountability mechanisms are poor or limited. And even under regulation that has much higher and more stringent safeguards, like the Digital Services Act, which has much greater possibility to fine companies involved, we still see that the transparency reports these companies publish are essentially trash. So given that very well-known problem that is in existence at this time, and that the lack of the quality of the safeguards, I think it's more of an issue of acknowledging that these things are, that automated decision-making is a real problem, and raising the standard of the quality of the surrounding oversight without just relying on humans in the loop to make everything okay. So the more oversight, the more accountability, the more transparency of high quality, the better the situation will get. And acknowledging right now that it's just not very good and there's a lot to be improved.
And there is a second question that I think is related to what I have heard right now. And it's about how, what are the implications, okay, of the AI Act requirements and notably human oversight requirements for small and medium enterprises, because they have scarce resources in order to implement human oversight or any other safeguard.
So I strongly support the idea that we need different regulatory regimes for the smaller and the larger organizations. It's clear, and their proportionality, as was already mentioned, is clearly the right approach. At the same time, the larger the organization gets, the higher quality the oversight and the mechanisms need to be involved in that. And I just add one thing that I forgot to mention before, but I think is quite relevant in these contexts. I would hope that over time we will get closer. We had medical regulation already mentioned, but I think we could also imagine financial regulation. If the existing reporting, so let's say the transparency reports, the mechanisms of oversight, the documentation required under the AI Act were not just provided by the companies, but audited. And in an ideal world that I would at least hope for, added as an annex to their financial reports, then if there were mistakes in those reports, that would have the same effect as if there's a mistake in an existing financial report to shareholders. If there's one number that's wrong there, suddenly that has considerable consequences for everybody that's involved. But these same consequences are not seen when the numbers are 1,000 too small here or 1,000 too large there. And that's just normal because it's a transparency report, so who cares? So if we start taking these mechanisms seriously and interlink them together in a way that causes actual consequences by putting them in places where doing things wrong has consequences, as is the case in financial reporting requirements, for example, I think we could get quite far quite quickly. And that also then applies to the context that we're discussing here right now. Human oversight, properly documented, properly shown, and the oversight structures properly defined in a way that if there's any errors in that, and that's clearly audited, then that would be a consequence. I would hope that that would also respond to some of the challenges that the speakers here have mentioned as well.
I think they do. I know that Claes.
Yeah, I'm sorry, just briefly, this is my favorite topic, SMEs. And, you know, in general, the AI Act simplifies things for small and medium-sized enterprises because it would be a mess for them otherwise. Now the societies invest a huge amount of money to set up ex-ante systems to help SMEs, and this will be on sectorial basis. And also, the AI Act does not regulate AI. It regulates, set up a system for how to regulate AI, how humans, and and there will be sector-specific solutions. So you have contact with an authority that defines exactly the standard in your business, which will make things very easy for SMEs. But now it's a mess. And before we get this in place, it's just question marks everywhere. But in the long run, this is a way to simplify for SMEs and not to make things more difficult.
Thanks, everyone. I think it has been a very lively discussion, and hopefully it will spark an interest. It has certainly in me. I really would like to thank Ben Wagner and Claes Granmar for being with us today, for having accepted to be our panelists at this IPEN event.